My name is Richard Owen. I'm from the University of Glamorgan, and in this lecture I'll be looking at sources of European Union law. There are 5 sources of European Union law: primary law, secondary law, general principles of European Union law, international agreements with non-EU states, and also in a common law system we would argue that decisions of the European Court of Justice are also a source of European Union law, but in civil law countries they might not agree with that. So we look first of all at primary sources of EU law. Now, one of the big differences between EU law and the British Constitution is that in EU law there's a hierarchy of legal norms, or put another way, that some laws are of higher status than other laws. So the primary laws are of higher status than the secondary laws, such as regulations, directives, and decisions. So if we look at the primary laws, the European Coal and Steel Community Treaty was the only one of the primary laws that was of limited duration and lasted from 1952 to 2002. All the others are of unlimited duration. And the most important primary laws, as far as we're concerned, are the Treaty of Rome, and its amendments by the Single European Act, the Treaty on European Union, the Treaty of Amsterdam, and the Treaty of Nice. But there are other important treaties, such as the First and Second Budgetary Treaty, and also the Merger Treaty. Now, if we start then by looking at the Treaty of Rome, also known at one time as the European Economic Community Treaty, but since amendment known as the European Community Treaty. If we look at its characteristics, when it was set up in 1957, it was very much intended to integrate types of economic activity. It, in a non-legally binding preamble, said it was an ever closer union, so it was envisaged there would be later treaties widening and deepening the process of integration. But first of all, in 1957, they were integrating types of economic activity. So they wanted to make sure there was free movement of the factors of production, free movement of goods, services, capital, and persons. Or in other words, although you had 6 original founding states, goods, services, capital, and persons could move freely around these states as if their borders didn't exist, even though they maintained a political status. And this was balanced out by common policies, a common commercial policy, going back to this idea of a trading bloc. So goods, persons, capital, and services could move freely as if borders didn't exist. Internally and externally, it was one bloc as far as the rest of the world was concerned. So trading conditions were the same regardless of which country, which member state you exported to if you were outside what is now known as the European Community. So a common commercial policy, a common competition policy. It was thought little point in making governments tear down their barriers to trade if those barriers to trade were simply re-erected by companies. So if they were going to form cartels and so on, it would defeat the object of the exercise. There was a common competition policy, there was a common agricultural policy, common fisheries policy, common competition policy, a common transport policy as well. And of great importance were the institutions that were set up to run this organisation. So there's a European Commission whose members are independent of national governments. So they operate independent of national governments. They have an important role. They initiate European legislation, for example, and that isn't under the control of national governments. There was a Council of Ministers, which was intended to give the national voice its say, because that consisted of government ministers. There was what used to be known as an assembly, now known as the European Parliament, which used to consist of delegates from national parliaments, but now consists of directly elected members. And there was a European Court of Justice as well. So that's what was set up in 1957. That was found almost 30 years later, in 1986, that there were certain problems, and there were still many barriers to trade. which shouldn't have been possible given this free movement. So why were there so many barriers to trade almost 30 years later after the so-called common market had been set up? Well, one of the main reasons was the so-called Luxembourg Accords. In 1966, the European community was meant to move from a system of unanimous voting to qualified voting. But the French president of the day, President de Gaulle, objected to this move to qualified voting. He withdrew France from participating in the European institutions, and as the political settlement to get France back in, they agreed the Luxembourg Accords, which were a constitutional convention. They didn't have the status of law, and basically it gave a national veto. It was expressed in a more long-winded way than that, but essentially that's what it was, a national veto. And it was found that this national veto had very much slowed down the decision-making process, and hence 29 years later they hadn't taken a lot of the decisions that were necessary to ensure free movement of goods, services, capital and persons. So as part of the Single European Act, they decided for so-called internal market measures, so purely for the free movement issues, not for the balancing policies, but for the free movement of goods, services, capital, and slightly exceptional case persons, they would take decisions by qualified majority vote. So the idea was to set themselves a timetable that identified all the legislation that was needed to ensure free movement of these factors of production, and they gave themselves a timetable from 1986, when the Single European Act was passed, to the 31st of December 1992 to pass all the legislation that identified as being necessary to ensure free movement. Now, how were they in 6 years going to achieve what they'd failed to achieve in 29 years? Well, they said on internal market measures, these free movement measures, they would make decisions by qualified majority votes. This unanimous decision-making had very much slowed down decision-making in Europe. Qualified majority voting would speed it up. And in many ways they were right to think this, because over 90% of internal market legislation was passed by the deadline of the 31st of December 1992. Now, the internal market legislative programme and its qualified majority voting was probably the most significant achievement of the Single European Act. However, it also widened and deepened the process of European integration in other ways. It gave additional powers to the European Parliament. And as members of the European Parliament had been directly elected since 1979, they were not under the control of national governments. So the more powers you're giving to a supranational organisation like the European Parliament, the more you're transferring them from national control. They had passed a new legislative procedure which allowed the European Parliament to force a second reading. And of course there's a delay inherent in the fact of a second reading. They spread powers into new areas, so they started to cooperate in terms of foreign policy. In 1957, when the Treaty of Rome was originally passed, they had no political powers. This was found to be unworkable, particularly at the time of the Falklands War. A British dependent territory, the Falkland Islands, was invaded by a non-EU state, Argentina. The United Kingdom obviously looked for support from its European community partners, and the problem they found was they wanted to take trade sanctions against Argentina, trade being an EC matter, but political sanctions against a non-member state, that was a political matter, and that was outside the EC. So they found there was this overlap between what was within their powers and what was out with their powers. So they started coordinating foreign policy powers. So no transfer of sovereignty when it came to foreign policy. With internal market measures, we'd seen a big transfer of sovereignty because qualified majority voting was used. A sovereign state could get outvoted and would still be bound. But when it came to foreign policy, they were coordinating their foreign policy. And moving into other areas as well. They were coordinating their monetary policy. So whereas there were no monetary policy powers in the original Treaty of Rome in 1957, in the Single European Act of 1986, they were starting to coordinate their monetary policy, not transferring their sovereignty at that stage, but trying to make sure that their interest rates and exchange rates were working together. And they moved into other new areas. They acquired specific environmental powers for the first time. Powers in other areas such as health and safety, consumer protection, recognition of academic qualifications, and so on. So that's the Single European Act, judged a success by the yardstick of the internal market legislation programme was achieved largely on time. And then we go on to 1993 when the Treaty on European Union came into force. The impetus behind the Treaty on European Union had been German reunification. This sort of created greater demands, particularly from countries such as France and Germany, to integrate Germany more closely into European structures. It had been a major objective of French foreign policy for some time to have a single currency and a timetable for a single currency, and that was probably the single greatest achievement of the Treaty on European Union. It laid down a timetable for a single European currency, the euro, which came into force in the early 2000s. It also set up a three-pillar structure. So on top of this three-pillar structure was the European Union. And this is the so-called tarpaulin over three pillars. So it was the tarpaulin over the first pillar, which is the European Community, and we spend most of our time looking at that pillar. Another pillar called Common Foreign and Security Policy, because again they were going to coordinate their foreign policy. It was a coordinating effort, although they could agree unanimously to move to qualified majority voting on specific issues. Essentially that was an intergovernmentalist pillar. And a third pillar, which is now known as police and judicial cooperation in criminal matters. So that three-pillar structure of the European Union, or the European Community, Common Foreign and Security Policy, and what is now known as police and judicial cooperation in criminal matters. It laid down a timetable towards economic and monetary union. It stressed certain general principles. So obviously it was an attempt at widening and deepening European integration. So it was stressing the common heritage of the member states. So it raised the importance of human rights protection within the European Union and enshrined that into the treaty, whereas previously fundamental human rights had been a general principle of EC law. Created a new general principle called subsidiarity. This origins of this was in Roman Catholic canon law, but it was taken up as a sort of politico-legal principle by the framers of the German Constitution after the Second World War. And it's this idea that you take decisions at the lowest possible level. And it was meant to be a bulwark against unnecessary creeping Europeanisation. So the decisions would be taken at the national level only, unless it was necessary for it to be taken at a higher level, at the European Union level. Created a concept of European citizenship. So everyone maintained the citizenship of their own member state, but in addition to that, they became European Union citizens. Now, initially it was thought citizenship rights were not tremendously significant, but there's been recent interpretation of this by the Court of Justice, which has extended these rights further than was initially realised. Other changes, in addition to economic and monetary union, was gave additional powers to the European Parliament. And again, you can see this as a deepening of the process of European integration, because the more powers you give to the supranational organisation, directly elected European Parliament, the less national governments can control things. And it brought in a new co-decision legislative procedure. It increased the use of qualified majority voting. So again, you're deepening the process of European integration. You're increasing the chances that a government might be outvoted and yet still bound by a decision of the European community. Gave powers in new areas such as culture, education, vocational training and youth, powers in the area of healthcare and so on for the first time, greater consumer protection powers, greater powers in what's called economic and social cohesion, in other words, a regional policy, a way of transferring money from the richer regions of the European Union to the poorer regions, and so forth. Now, there was a social protocol attached from which the United Kingdom opted out, and the United Kingdom and Denmark also opted out from the third stage of economic and monetary union. And this was a significant legal development, because up until this stage there had been a principle of uniformity where all EU law applied in the same way in all member states. Sometimes the state would be given longer to comply, but they're all working towards the same law. Now, for the first time, we have a variation. We have the United Kingdom saying they're not participating in what was called a social policy agreement, which was the next to the social policy protocol. That was subsequently renounced in 1997, but to this day there are opt-outs given to the United Kingdom and Denmark when it comes to the third stage of economic and monetary union, and that's why the euro is not the currency of the United Kingdom or Denmark. And in some ways this signifies what's become known as a multi-speed Europe. Some countries moving further and faster towards European integration than others. So that was a significant legal development. We then move on to 1999 with the Treaty of Amsterdam. Now, the reasons behind the Treaty of Amsterdam were to prepare the European Union for enlargement towards Central and Eastern Europe, because many of these countries now wish to join following the collapse of the Berlin Wall, and also as a way of preparing the European Union for this enlargement to slimline its institutions. And the Treaty of Amsterdam was also thought necessary to reconnect to the people of Europe, because the Treaty on the European Union had proved an extremely hard treaty to ratify. It had only been very narrowly approved in France, which came as a surprise because a single currency had been an objective of French government policy for some time. There was a serious legal challenge to it in Germany. It proved very hard to get through the UK Parliament, and it was initially rejected in a referendum in Denmark. And following certain agreements, it was subsequently approved by a Danish referendum. Now, the lessons that were drawn from this experience of finding it very hard to ratify the Treaty on the European Union was it was thought that the European Union had become too disconnected from the ordinary citizen, that they were too concerned with monetary policy, which of course had now been transferred to the European Union, at least for those countries participating in the European single currency, and too far removed from concerns such as education and health, employment, which are the everyday concerns of the great mass of citizens. It was an attempt to sort of reconnect, so it had employment powers for the first time, with the United Kingdom renouncing its opt-out from the social policy agreement, which is annexed to the social policy protocol. The reduction in the size of the Commission was something that was not agreed at Amsterdam, and it became the so-called Amsterdam leftover, and it was left to the Treaty of Nice to reduce the size of the European Commission. It gave new powers again to the European Union, beefing up public health provisions and so on, additional powers to the European Parliament, increased use of qualified majority voting again, which again signifies a deepening of the process of integration. But the Treaty of Amsterdam wasn't an entirely successful treaty because they couldn't get full agreement on reducing the size of the Commission, which was left to the Treaty of Nice, which came into force in 2003. This was meant to be a two-stage reduction in the size of the European Commission. First stage has already occurred. The second stage is yet to occur. Again, the Treaty of Nice signified a reduction in qualified majority. Signified an increase in the use of qualified majority voting, an increase in the use of the co-decision procedure, where the European Parliament can veto legislation, so an increase in their powers as well. And they also said there would be a yellow card procedure for any country that breached EU democracy, principles of EU democracy. This idea that if you're enlarging the European Union and you're taking in states that have very recently been under totalitarian control, you needed to make sure democratic principles were going to be observed and respected. So a so-called yellow card principle was introduced. Now, by this stage, obviously, we'd had the Treaty of Rome amended several times. It was somewhat messy. It was thought there was a need to simplify the procedure, and this led to a constitutional convention which set up the treaty establishing a constitution for Europe. Now, this was agreed by all member states, but it will never come into force following its rejection in referenda in France and the Netherlands in 2005. However, the Treaty of Lisbon, which has been the following treaty, does contain 90% of what was in the treaty establishing a constitution for Europe, which I'll call the Constitution Treaty. So we need to give some thought to the Constitutional Treaty, because in some ways you can only understand the Lisbon Treaty if you have some knowledge of the Constitutional Treaty. The Constitutional Treaty was in 4 parts. It was going to repeal all the existing treaties. I mean, it would replicate many of their provisions, but the idea is you can have one simplified document rather than a treaty that's been amended 4 times. You have one simplified document. And the first part contained the important basic provisions. Part 2 contained the fundamental rights and was taken up mainly with the Charter of Fundamental Rights. Part 3 consisted effectively of a replication of the EC Treaty, and Part 4 was general and final provisions. Now, what was significant about the Constitutional Treaty? Well, it contained a number of changes to the EU's institutions, which we'll look at separately. It abolished the EC and was going to make the European Union one unitary idea. So instead of this European Union, which is a tarpaulin of the 3 pillars, the European Community, common foreign and security policy, what is now known as police and judicial cooperation in criminal matters, we're going to just create one European Union. So simplify its structure and give legal personality to this European Union, so that the European Union could enter into international treaties as opposed to the European Community. There's going to be a flag, anthem, motto and currency for the European Union, an explicit statement that EU law would have primacy over conflicting national law, although that had been a principle of the Court of Justice since the early 1960s. It hadn't actually ever been enshrined in legislation. A solidarity clause, so in case of natural disaster or whatever, member states will come to each other's aid. Changes to the system of qualified majority voting, a clear specification of the powers between the member states, a greater role given to national parliaments in EU affairs, a legal right for member states to withdraw from the European Union, and so on. Now, it was rejected by referenda, as I said, in France and the Netherlands. This led to a period of reflection before we had the Treaty of Lisbon, which is agreed by all 27 member states. At the time I speak to you, it has been ratified by 25 of the member states, but was rejected by a referendum in the Republic of Ireland in June 2008. And the current plan, although there's no certainty this plan will come to pass, is that it comes into force at some point in 2010, following a further referendum in Ireland, presumably following certain assurances given to the Republic of Ireland as well to ease its passage. Now, one of the current hot issues is the Treaty of Lisbon significantly different from the Constitutional Treaty? Now, the reason why this is a hot topic was in countries such as the United Kingdom, a referendum had been promised on the Constitutional Treaty, whereas the Treaty of Lisbon was ratified by the UK Parliament without recourse to referendum. So are the differences significant? I mean, everyone seems to agree that the content is 90% the same, but as one MEP puts it, the DNA of mice and humans is 90% the same. It's the 10% that's different that causes all the differences. So what is specifically different? Well, the Treaty of Lisbon is an amending treaty. So whereas the Constitutional Treaty was trying to simplify everything, get everything into one document, the Treaty of Lisbon will amend existing treaties. So it doesn't really achieve that goal of simplification that the Constitutional Treaty set itself. So in terms of legal process, that is quite quite different. The Treaty of Lisbon will eventually disappear, and the idea is that it'll amend the existing Treaty on European Union and it'll amend the existing EC Treaty and rename it the Treaty on the Functioning of the European Union. We'll still have a unitary European Union, so the idea of a European community will disappear. We won't have this idea of three different pillars. There will just be a European Union. And that is, in terms of legal process, that's one of the biggest differences between the two treaties. Now, both treaties had a double majority voting system. It's the idea you move away from qualified majority voting with countries given so many votes, but you have a double majority voting system where it's done on terms of population. If 55% of the population agree, European Union's population agree, and a measure is passed, provided that represents 65% of the member states. Now, it's been brought in over a longer transitional period as a result of the Treaty of Lisbon, and that was really to assuage the fears of the small and medium-sized states. This is obviously not to their advantage. It further beefed up the role given to national parliaments. Under the constitutional treaty, there could be a so-called yellow card system. Now, under the Treaty of Lisbon, again, a role will be given to national parliaments in the passing of EU law for the first time. But there is an orange card system, whereby that if over 50% of national parliaments object to a measure and the majority of the parliament and the council agree with them, then a measure will get scrapped. And an orange card system is specifically new. Now, whereas the Charter of Fundamental Rights was produced in full in the Constitutional Treaty, it is merely cross-referenced in the Treaty of Lisbon, and two written guarantees were given to the UK and Poland. Now, there was an academic debate as to whether these written guarantees are reassurance to the UK and Poland or whether they are opt-outs to the UK and Poland. Lord Goldsmith, who negotiated them on behalf of the UK, says they are written assurance rather than opt-outs. So those written guarantees given to the UK and Poland in relation to the Charter of Fundamental Rights is another big difference between the Constitutional Treaty and the Treaty of Lisbon. Now, the goal of free and undistorted competition was dropped, and that was because of concerns that have been expressed during the French referendum on the Constitutional Treaty. Accession criteria were written in to the Treaty of Lisbon, and that was because of fears in the Netherlands over expansion and fears that the new member states would not respect human rights. So those are the major differences between the Constitutional Treaty and the Treaty of Lisbon. Now that finishes looking at primary sources of law. As I said at the beginning, the hierarchy of legal norms in EU law. So those founding treaties are the highest forms of law. Now the secondary laws, they can be annulled or declared invalid if, amongst other things, they infringe those primary laws. So what are the secondary laws? They are regulations, directives, and decisions. So briefly, regulations bind everybody. So they're binding on everyone in the EU, and then what are known as directly applicable. They don't need national legislation to give effect to them. Directives are only binding on member states. Now, in this context, we mean national governments or public bodies. And they set a result to be achieved. If you like, they set a binding aim. So they need national legislation to achieve that aim, and decisions are addressed to specific addressees. So that could be one person or group of people. So those are the secondary forms of legislation. There are also general principles of EU law. The most important, probably the general principle of fundamental human rights. The specific applications of that then in the general principle of equality and the general principle of proportionality. And this we'll look at a lot when we look at internal market law, because the principle of proportionality says the legislature cannot go further than is necessary to achieve its aim. It's intended as a form of human rights protection. So those are the main general principles of EU law. Now, in addition to that, agreements with third countries, agreements with non-EU countries are another source of EU law, and you could argue, and certainly in a common law system, we would tend to think that decisions of the European Court of Justice are a source of EU law as well.